So good morning, everybody, and welcome to the final trial for the 10th annual in Vino Veritas National Mock Trial Competition. We're excited to get started today, and before we do, we'd like to have our presiding judge, Judge Dorothy Chow Proudfoot, introduced by our timekeeper. Her name is Ashley Yamas, and she'll be reading a bio about the judge before we start.
Good morning, everybody. Dorothy Chow Proudfoot is an administrative law judge at the San Francisco Rent Board, where she has presided over arbitration hearings in residential rent control cases and mediated landlord-tenant disputes since 2018. She earned her undergraduate and law degree from University of California, Berkeley. She practiced civil litigation at Heller Ehrman LLP before spending 16 years as a deputy district attorney in Marin County, specializing in gang violence and sexual assault offenses. From 2008 to 2009, she was also cross-designated as a special assistant United States attorney prosecuting federal offenses in the Northern District of California. She is the immediate past president of the Earl Warren American Inn of Court and the chair of the Administrative Law Judges Committee of the California Asian Pacific American Judges Association. She also serves on the Administrative Judiciary, Judicial Independence, and LGBTQ committees of the National Association of Women's Judges. A sustaining member of the Asian American Bar Association of the Greater Bay Area, she also serves on its Public Law Committee, as well as the Centennial Committee of Queens Bench Bar Association. She previously served on the Board of Governors of California Women Lawyers, was the Vice President of Women Lawyers of Alameda County, served on the Marin County Judicial Fairness Committee, and in 2017 was the first Asian American president of the Marin County Bar Association. She has coached, scored, and presided over mock trial and moot court competitions for 12 years and has served on the Cal Band Alumni Association Council for 2 decades. We are so thrilled and honored to have Judge Proudfoot as the presiding judge for the final trial this year.
Thank you, Ashley. Yeah, thank you so much. And really quickly, just as an introduction to our court reporters that we have a supervising court reporter, Ana Fatima Costa, and our 3 court reporters that will be helping us out during the trial and taking down what's happening is Shai Stevens, Sierra Kagan Zanghai, and Chandler Alvino. And with that, I will hand over the courtroom to the presiding judge, Proudfoot. Thank you so much.
Thank you, Professor Brockle. It's my pleasure to be here this morning. We are here on the case of Phoenix Burns versus Corker Wines and Sydney Corker. But before we go on the record, I would actually like to ask our court reporter to give the initial admonitions that I understand are in order.
Good morning, Your Honor. Good morning, everybody. My name is Sierra Zengi. I will be the court reporter on the record today. I am a court reporter and a candidate in the state of California. As a reminder, it is my legal and ethical duty to capture the record and make sure that we are taking down everything accurately today and to defend that record. So I'm sure that Her Honor will be interrupting if she needs to, but I will also be interrupting if for any reason or for whatever reason, I'm not able to hear or understand what is being said. So if you hear my voice or if you see me waving my hands, please just take a moment, we'll clarify and then we'll move on. All right, with that, thank you very much, Your Honor, and we'll proceed.
Thank you, Ms. Zengi. And just wanted to add to that admonition, it is your obligation to pay attention to the court reporter and make sure that if she's having any difficulty hearing or understanding you, that you adjust it appropriately. If the matter requires that I step in, I believe that is certainly going to reflect on my score of you, and the evaluators, that's up to their discretion. So thank you so much. Are both sides prepared to begin?
Yes, Your Honor. Ian Lindsay on behalf of the plaintiff, along with my co-counsel, Judy Catan. When you're ready, we have 3 matters of housekeeping.
First, I'd actually like to confirm that both sides are ready. Is the defense ready as well?
Yes, Your Honor, the defense is ready. And my name is Lindsay Hanselman, and along with my co-counsel, Christina Boyle, we represent Sydney Corker and Corker Wines in today's matter. And for your reference, we are Team H.
Okay, thank you. And I understand, is plaintiff Team E?
Yes, Your Honor.
All right, thank you. It sounds like we have 3 preliminary matters that the plaintiff would like to raise. So I'll start with those, and I'll also give the defense an opportunity to raise any preliminary matters after we deal with the plaintiffs. So Mr. Lindsay.
Thank you, Your Honor. First, By way of stipulation for a buy-in between the parties, it has been stipulated that both Monty Burns and Blair Pickus will be constructively testifying today as live witnesses, even though we won't be able to hear or see them. We will be referencing and relying on the testimony that is elicited there, and that testimony would be consistent with the deposition testimony they gave in this case.
Okay, I understand that from the rules of the competition. So what's your second?
Our second is that because we are not able to actually cross-examine Blair Pickus, it has been stipulated in stipulation 14 that Blair Pickus has a 2015 misdemeanor fraud conviction, and that would have been constructively elicited on cross-examination of him for purposes of impeachment. And we will be referencing that in our closing argument.
Okay, any problem with that, Ms. Hanselman?
No objection, Your Honor.
My understanding is that would be consistent with the rules of evidence. Thank you.
And the third one is a minor one. I wanted to clarify whether our warnings for time in closing would be verbal or whether they would be through chat.
Okay, I think we had our timekeeper state that earlier. I'm going to ask the timekeeper to come on camera again and please explain how you're going to be giving those warnings.
Good morning, everyone. So I am the timekeeper for the plaintiffs, for you on the plaintiff side. So I will be giving both a chat warning as well as a verbal warning in case you do not see the chat warning. So I will make sure that you do know when your time is coming to a close.
Thank you very much.
And just to be extra clear, that will be the same for the defense side as well.
Thank you.
All right, thank you, Ms. Yamas and Ms. Robinson. Anything further from the plaintiff as far as preliminary matters are concerned?
No, Your Honor.
All right, and I just wanted to remind everyone, speak a little bit slower than you're used to speaking. I find myself doing it. I am a person who speaks very quickly in real life. So here on Zoom, please speak just a little bit slower than you think you normally would. Let me turn now to the defense. Does the defense have any preliminary matters that you would like to raise at this time?
Yes, Your Honor. The defense just has two additional preliminary matters. First, we wanted to let the court know that due to the nature of this forum, when entering exhibits, we intend to direct witnesses in the court to the exhibits in the packets that have been provided, along with a page number. And then only once the exhibit has been entered, we will request permission to publish via the share screen function.
That I believe is actually an appropriate procedure in court as well. And I would expect both sides to adhere to that. You can't share screen something for the jury that has not been admitted unless there's a stipulation from counsel. Okay, and the second matter?
Yes, and our second matter is that we intend to use PowerPoint presentations in both our opening statement and closing argument. And we have conferred with opposing counsel beforehand and believe they have no objection to that.
Let me turn to Mr. Lindsay. Are there any objections to the slides of the opening PowerPoint statement?
No, Your Honor. Counsel was kind enough to share that with us prior to meeting here, and we have no issue.
Okay, and if I understand that the exhibits are going to be shared via PowerPoint, has each side had an opportunity to make sure that their technology is set up properly so that we won't have any technical problems as those are being displayed?
Yes, Your Honor, the defense has all of our technology ready, so we are hopeful that we won't have any problems moving forward.
Okay.
And yes, thank you to the court's kindness for allowing us to get reset with our technical difficulties. We are ready to proceed.
Okay, with that then, hearing no more preliminary matters to be dealt with, I'm ready to proceed on to the trial. I'm sure that both sides need no reminder that you have 65 minutes to present your portion of the case. And that 65 minutes is up to you as to how you apportion the time. We'll be going through, we've talked about the timekeeping, we've talked about the exhibits. And so at this time, I'd like to ask the plaintiff if you would like to give your opening statement at this time.
I would. Thank you, Judge. A student is only as good as his teacher. When a young man dies, because the owner of a company allows his unqualified employees to train others on dangerous machines, that owner must be held liable. Because the defendant, Sidney Corker, failed to properly maintain and supervise his vineyard, Charlie was improperly trained on a dangerous machine. And Charlie drove that dangerous machine to finish a job that he was not equipped to do. And by the end of it, Charlie was electrocuted and suffered an excruciating death. Ladies and gentlemen, this is why we are here today. Charlie was 23 years old. He was a young man, but he was also a son to Phoenix Burns and a big brother to Monty Burns. Charlie took it upon himself to spend as much time as he could with his little brother. And he took every opportunity to do that, including on his days of work. He would bring Monty along when he could. And Charlie wanted to become a social worker. He wanted to give people hope. But before he had an opportunity to fulfill that dream, Charlie was killed. And now we have one less son. And we have one less big brother. This all began on October 16th, 2018, when Blair Pickus, an employee on the defendant's vineyard, was up and ready for another day of work. He had a note from his employer, the defendant, to put up signs by the trees on the vineyard and to trim those trees. Blair focused on trimming those trees, and he knew that they were so tall, he would need a boom lift to reach them. Now, a boom lift is a giant machine. It weighs 16,000 pounds, and it has a bucket that someone can sit in and be raised up to 50 feet in the air to work on big projects. It requires formal training and at least 2 people to safely operate. In order to use it, you need to be aware of all of the safety hazards. You need to know all of the rules, like the rule that you should never get within 20 feet of its power lines. Now, this type of awareness, it comes through formal training. It comes through OSHA certification. And an employee is put in serious danger when they don't know what to look out for, when they don't know what the hazards are, and especially when they don't have a second person to spot them. Now, Blair was an untrained employee. We know this because he only offers us the limited background of being an auto mechanic and his general experience in maintenance. But Blair didn't know or follow the safety rules of operating a boom lift. So Blair, without formal training, got the boom lift. And without a second person to spot him, took it to those trees, breaking his first safety rule. Blair parked it under those trees and was lifted within 20 feet of those wires, breaking his second rule of safety. But Blair was lucky on that day, and nothing happened to him. By the end of his long day of work, Blair realized that this job would take at least a few days, and he was off of work for the rest of the week. And on the vineyard, when a job is unfinished, it's normal for employees to just leave the boom lift out for another employee to pick it up and finish the job. So Blair did just that. He left the boom lift and he left its keys somewhere on the vineyard for another employee to finish the job. Charlie was that employee. On the very next day, Charlie was headed to work. This was no surprise. His father had seen Blair training him on the boom lift before, showing him how to move it up and down. So Charlie grabbed his tools, including the one that he needed the most, a saw. Charlie found his younger brother and brought him along to spend some time with him. And Charlie found the boom lift where Blair had left it. And Charlie headed straight for those trees to finish the job that Blair had started. And like Blair, he parked it under those trees. And like Blair, he was lifted within 20 feet of those wires. But unlike Blair, Charlie was not as lucky. As he was going up, Charlie didn't know what was waiting for him in those trees. Charlie couldn't see what was waiting for him in those trees. Charlie had no idea that 86,000 volts of electricity were running through the wires in those trees. And as he went up, before seeing the danger, Charlie was hit. And in that very moment, without a single warning, 86,000 volts of electricity went coursing through every inch of Charlie's body. He immediately lit on fire in front of his little brother. Charlie was alive for 3 minutes. 3 whole minutes before the electricity put an end to Charlie's life. Ladies and gentlemen, these facts tell you a story. Charlie wasn't just living on the vineyard on October 17th. Months before, his father had seen Blair training him on the boom lift, showing him how to move it up and down. The day before, Blair claims to have lost the keys to the boom lift, something that he didn't tell anybody until days after Charlie died. And on the day that Charlie went to work, he brought a saw with him, a tool that you use to trim branches off of trees. He made the same mistakes that his teacher made in getting within 20 feet of those power lines, in not having a spotter on the ground to spot him. And Charlie died in the same place where Blair had been working just the day before. And on the next day, on the very next day after Charlie died, the defendant and Blair met up alone. They spoke in private. And now they're telling you the same story. But the evidence will tell you something different. The evidence will show you that the defendant didn't have qualified employees, that the defendant didn't even know who they were training, and that the defendant didn't put warning signs where he needed them the most. And now, Phoenix lost his son. Monty lost his brother. And Charlie lost his life. Ladies and gentlemen, at the end of this trial, my co-counsel Ian Lindsay will show you that every single element of negligence has been proven to you by a preponderance of the evidence. And then we will ask you to find the only verdict that the evidence supports and that justice demands. Find the defendant liable for the death of Charlie Burns.
Thank you, Ms. Catan. Let me ask at this time, does the defense wish to give an opening statement at this time or defer?
Yes, Your Honor, we'd like to give an opening statement.
Okay, go ahead when you're ready.
Charles Burns, who was 23 years old, forced his way into a locked barn, fumbled with the controls of a machine, a boom lift. He punched and moved the buttons and levers, struggling because he couldn't see well. He wasn't wearing his glasses, and he had just been drinking. He convinced his younger brother, Montgomery Burns, who was 16 years old, to hop in the bucket of the boom lift with him. He finally got the safety off and heard the engine of the lift roar to life. He moved the basket out of the barn and raced it along the roads of the property. Treating it like a toy, he lifted the bucket up and down and flew down these roads at an alarming speed for such a heavy piece of machinery. With no concern for his safety or the safety of his younger brother. And with the bucket of the boom lift raised high in the air, he swung the bucket into the power lines, electrocuting himself, killing himself. Now, this accident happened on Mr. Corker's property, Corker Wines, a community-oriented vineyard. And Mr. Corker rented a house on this property to the Burns family. Now, Sidney Corker did what he needed to do to protect the people on his property. Tragically, it was the actions of Charles Burns himself that led to his death. You'll hear that Charles Burns ignored the warnings on the power lines. He evaded the restrictions on the boom lift, and he drove this heavy piece of machinery dangerously. Members of the jury, the plaintiff must prove to you by a preponderance of the evidence that Mr. Corker acted unreasonably. As we go through trial, I want you to remember a few things about reasonableness. First, we don't expect business owners to think of every potential thing that could happen on their property. And Mr. Corker's actions do not have to be the most reasonable precautions he could have taken. They just have to be reasonable. Now, I want to start with the power lines. There were power lines on Mr. Corker's property, but he didn't put them up himself. He's not an electrician. His specialty is wine. And Mr. Corker trusted the utility company to put up and maintain these power lines. Now, Mr. Corker knew there were power lines on his property because the power lines were open and obvious. In fact, Montgomery Burns will tell you that he saw the power lines from the lift just before the accident. Not only were these power lines open and obvious, but there were warning signs all over the property. Warnings that said, danger, high voltage. Charles Burns ignored these warnings. Sidney Corker also restricted the boom lift. He restricted both who could operate the boom lift and who could access the boom lift. He restricted who could operate the boom lift because he limited the number of employees who were authorized to use it. And those select few that were authorized were properly trained on the dangers of using the lift and of overhead power lines. And then there was a warning on the boom lift itself to remind the employees when they used the lift of these dangers. Sidney Corker also restricted who could access the boom lift. This boom lift was kept in a locked barn. Now, we know the boom lift was kept in a barn because this is an electric lift. It had to be plugged in to charge. And Blair Pickus will tell you that the day before the accident, he locked the boom lift in that barn. And only 2 people have keys to access that barn, Mr. Corker and Blair Pickus. Charles Burns evaded these restrictions. Members of the jury, this case is about common sense and whether Charles Burns used common sense on the day of the accident. Now, the plaintiff told you that Charles Burns took this lift for a ride. But I noticed the plaintiff failed to mention that Charles Burns was not wearing his contacts, that he had just been seen drinking, and that he was speeding the boom lift. Now, let's walk through the circumstances on October 17th, 2018 that you'll hear about. Sidney Corker did not authorize or train Charles Burns because he wasn't an employee of Corker Wines. And Blair Piggis locked that boom lift in the barn the day before the accident. Now, Dr. Faustner is a boom lift expert, and Dr. Faustner will explain that a boom lift can actually be started with a screwdriver. Montgomery Burns, who was in the lift with Charles that day, will tell you Charles was not wearing his contacts and that he had just seen him drinking his favorite bottle of wine. Now, Charles Burns was also driving over 15 times the recommended speed limit for the boom lift. By driving fast and not paying attention, Charles Burns not only endangered himself, but he endangered his younger brother. Not every tragedy is the fault of someone else. And unfortunately, it was the actions of Charles Burns himself that led to his death. Charles Burns ignored the warnings of the power lines. He evaded the restrictions on the boom lift, and he drove this heavy piece of machinery dangerously. At the end of this trial, my co-counsel, Ms. Hanselman, will come before you and walk back through all the evidence. It's at that time we will ask you find the only verdict the evidence supports. We ask that you find Sidney Corker was reasonable and find Charles Burns 100% liable. Thank you.
Thank you, Ms. Boyle. Would the plaintiff please call your first witness?
Your Honor, at this time, we would have constructively called Montgomery Burns.
Montgomery Burns will be deemed to have testified.
Thank you, Your Honor. Next, we call Phoenix Burns, to the stand.
All right, are we proceeding as if Mr. Burns has already been sworn?
Mr. Burns, good morning. Would you please introduce yourself to the jury and spell your name for the record?
Yes, my name is Phoenix Burns, B-U-R-N-S.
And Mr. Burns, who was Charlie?
Charlie was my son.
And in a moment, we'll talk about the day that Charlie died. But first, I want to talk a little bit more about him. How old was Charlie when he was killed?
Charlie was 23 at the time he was killed. He was coming up on his 24th birthday, actually.
And what did he do in his free time?
Well, Charlie was a great kid. He loved to spend time with his family. He also was trying to get his GED. He wanted to go to junior college.
What was he trying to study?
Charlie wanted to become a social worker. His own life had some ups and downs, and he wanted to show other people that there was still time to change, wanted to make a difference in other people's lives.
Where was he living at the time of his death?
He was living with me. We lived on the Corker Wines property when he was killed.
Was there anyone else who lived in the home?
Yes, my son, Monty Burns, Charlie's younger brother.
And how old was Monty at the time Charlie was killed?
Monty was 14 at the time.
And what was Charlie's relationship with Monty like?
Monty and Charlie were very close. They were like best friends. You could tell that Monty really looked up to Charlie, and Charlie kept Monty under his wing, protected him.
And you mentioned that you lived on the defendant's property. How did you come to live there?
I'd heard through a friend of mine that Mr. Corker rented out a farmhouse on his property, a 2-bedroom farmhouse. I got in touch with him, and after speaking with him, he agreed to rent the property to me.
And when he rented the property to you, did you have to sign any kind of lease?
No, he just told me to give what I could for a security deposit. We shook hands, and he said, have rent ready by the 1st of the month.
Did he have you go through a background check?
No background checks.
Was there any written documentation of your arrangement together?
No, like I said, we just shook hands on it.
And how far away from where Charlie died were you living?
Our home was across a field from the service road where the power lines were that killed Charlie.
And how long did you end up living at that home?
We lived there for about a year, a little over a year.
Mr. Burns, let's talk about the day that Charlie was killed. How did that morning start?
Started like any other morning. Charlie came down. He was in a great mood, big smile on his face. Me, him, and Monty had breakfast together. We were watching TV and just hanging out, talking, family time. And then at some point, Monty left later that day.
And what did you and Charlie do the rest of the day?
Charlie and I spent time together. We were hanging out into the afternoon, and then he mentioned that he wanted to go out and meet Monty on the vineyard.
Did he go meet Monty on the vineyard?
Yeah, so he used my phone, called Monty and left a voicemail letting him know that he wanted to meet him out there. And that's what I assumed he was going to go do.
So what happened after that?
Then Charlie left. That was the last I saw him before he was killed.
Let's talk about the boom lift that Charlie was killed on. Have you seen that boom lift anywhere on the property before?
Yes, I have.
Where have you seen it?
I've seen it all over the property. Seen it on the side of the road. I've seen it on the road itself, in the fields, even next to our house a couple of times.
And has anyone on the property ever shown you how to use it before?
No, nobody's shown me that.
Have you ever been on it yourself?
No, I wouldn't know how to begin to operate it.
Have you ever started it yourself?
Again, no, I don't know how to.
Have you ever seen Charlie anywhere around this boom lift before?
Yes, I'd seen Charlie with Blair Pickus. They were out near the boom lift.
And who is Blair Pickus?
Blair Pickus is one of Sidney Corker's employees. From my understanding, he's a sort of higher up, oversees a lot of different parts of the property.
And approximately when did you see this happen?
This was a couple of months before Charlie died.
And Mr. Burns, what did you see the two of them doing?
I saw Blair Pickus showing Charlie how to move the arm of the machine up and down.
No further questions, Your Honor.
Thank you. Cross-examination?
Yes, Your Honor. Hello, Mr. Burns. I understand this may be difficult for you, but I need to ask you some questions about Charles. And I'd like to start with, he was living with you at the time of the accident?
Yes, he was.
And on October 17th, you testified on direct, you spent the day with Charlie.
Yes, I spent my morning with Charlie.
And around 3 p.m., he went to go hang out with Montgomery.
Yes.
And Charles did not say he was going to work.
No, just that he was going to meet up with Monty.
Right. In fact, he never told you he was going to work on Sidney Corker's property.
No, not that day.
Not that day or never in general, Mr. Burns.
He did not tell me that day that he was going to meet up with Monty.
And he never told you on any previous day that he was working on Sidney Corker's property?
No, I heard stories from him about being able to see the property from the top of the boom lift.
Right, but Mr. Burns, Charles Burns never told you that he was working on Sidney Corker's property. That's a no?
No, he'd never told me that.
And Mr. Burns, your house that you rented was on the property with a view of the vineyard.
Yes, I mean, we could see the vineyard. We lived on it.
And you never saw Charles Burns working on that vineyard?
No, I did not. I had a job myself.
And on the instance you testified to on direct, where Blair Pickus was showing something to Charlie on the boom lift, you were not close enough to hear what they were discussing.
No, not that I can recall.
And Mr. Burns, you did not see the boom lift out on October 17th, 2018.
I did not.
Now, I want to talk about the power lines on the property. You are aware that there are power lines on the property,
Yes,
and those power lines line several roads on the property.
yes, they're in various locations on the property.
And your house is approximately in the middle of the property?
In the middle of one plot of it, yes.
And you had to use these roads to go to and from your house.
Yes,
So, Mr. Burns, you drove on roads lined with power lines to get to your house.
I can't recall if there were power lines on the roads I drove on to leave my home, but I know there were power lines on the service road that Charlie was killed on.
Mr. Burns, I'm not asking whether you recall that there are power lines there. I'm asking whether you are aware now that you did drive on roads that had power lines on them to get to your house.
Again, I don't know if there were power lines even now on the road that I drove to leave my house.
Mr. Burns, you gave a deposition in this case,
Yes,
and in that deposition, you discussed the power lines on the roads.
yes, on the service roads.
And in that deposition, you said that you were made aware that these power lines are now lining these roads.
Yes, again, the service roads on the property.
Now, Mr. Burns, as a matter of fact, those power lines were just 200 feet from your house.
That sounds about right, yes.
And these power lines were actually visible from the window of your house.
I suppose you might be able to see them from the window. Yeah,
And now, Mr. Burns, I want to talk about the expectations of living on the vineyard. Now, you rented this house on Sidney Corker's property,
yes,
and you knew this was a winery.
yes,
You knew this was an operational winery.
yes, I did.
And because you knew it was an operational winery, you knew there could be some heavy machinery.
Yeah, I guess. I mean, I figure they mostly are planting, tending to the fields, but sure.
And, you know, machines like that can be dangerous.
Sure.
Now, Mr. Burns, when you rented this property, you didn't set any boundaries on the property for your children.
No, Charlie was 23 at the time.
Exactly. Charles was 23, so you didn't need to warn him.
I did not.
Now, Mr. Burns, your agreement was to rent just the house on the property.
Yes,
You weren't renting Sidney Corker's property as a whole.
no,
And Mr. Burns, you and your family had no reason to be in Sidney Corker's workshops.
no, we had no reason.
And you had no reason to be in Sidney Corker's barn.
Yes,
Sorry, just to clarify for the record, you had no reason, and you're saying that you did not have a reason. Is that right?
yes, sorry. Yes, we had no reason.
And you and your family had no reason to use any of the heavy equipment on the property.
Correct.
And Charles Burns never told you he had permission to use this equipment.
He never told me he had permission, but he told me he had been on it before. So
Right, Mr. Burns, my question is much more simple. I'm asking whether or not he had permission, or he told you he had permission to use the boom lift.
he never told me that. No.
No further questions.
Thank you. Any redirect?
No, Your Honor.
Is this witness excused?
Yes, Your Honor.
All right, thank you. Does the plaintiff have, before we go to the next witness, I'm going to take a 90-second to 2-minute break for purposes of switching over the court reporter.
Thank you, Your Honor. My name is Chandler Alvino, and I will be relieving Sierra. Everyone's pace has been great so far, but just as a reminder, I will be speaking up if I cannot hear or understand anyone. Thank you.
Thank you, Ms. Alvino. I should let you know that your volume is actually quite low. So if you find the need to speak up, please, either lean closer to your device or raise your voice just a little bit. It might be hard to hear you if you do need to speak up. Are you otherwise ready to proceed?
Yes, Your Honor. Thank you.
Thank you, Ms. Alvino. I just need a moment here. All right, Ms. Catan, your next witness, please.
Yes, thank you. The plaintiff would now like to call Dr. Knupel to the stand.
Dr. Knupel, you have been previously sworn for all witnesses as well. You have been sworn. So go ahead, Ms. Hanselman. Ms. Catan.
Thank you. Dr. Knupel, good morning. Please state your name for the record.
Hello, my name is Eric K. Knupel.
What brings you here today?
The death that occurred on the Corker winery.
And what have you been asked to do in the present case?
I was asked to investigate the electrocution of Charlie Burns and to determine the circumstances and what could have been done to prevent it.
Now, before we speak about your opinions, I want to get into your background and education. What do you do for a living?
I'm a human factors, biomechanical, and electrical engineering expert and the owner and CEO of my own firm Invisitech.
What is a human factors expert?
Human factors is a specialty study of psychology and human behavior, and it studies the interactions of all types of machines and equipment in different environments. So, for example, I specialize in things like human error, work site safety, and human machine interactions.
And what is your work history?
I've provided many consultations to various companies and law firms, as well as expert testimony at depositions, at trials. I also have some experience in safety consulting to prevent workplace accidents, many of which have involved electrocution.
How many years of experience do you have?
Over 20.
And what did you go to school for?
I have a PhD in engineering from the University of California in bioengineering, and I have a minor in electrical engineering, and I am also a board certified professional ergonomist.
What's an ergonomist?
It's a profession that is concerned with the safety and efficiency of equipment, systems, and transportation, and it works to ensure the health and protection of any users of this equipment through scientific research.
Have you been published before?
Yes, I have. I have over 60 publications and decades of experience as an experimental psychologist and a human factors engineer.
Have you testified as an expert before?
Yes, I have.
How many times?
over 500 times.
And how did you use your experience to form your opinion?
Well, my experience and my education requires me to be very familiar with the psychology of people in workplace situations and accidents. In this one, which would involve electrocution, which basically means that I have an understanding how people process dangerous and hazardous workplace situations.
Have you formed any opinions in this case?
Yes, I have.
And the opinions that you will provide, are they based on a reasonable degree of scientific certainty?
Yes, they are.
Are the methods that you relied on commonly relied upon in your field?
Yes, they are.
Your Honor, at this time, I would like to tender this witness as an expert in the field of ergonomics and human factors.
Ergonomics and human factors.
Yes.
Ms. Hanselman?
No objection, Your Honor, but we would ask that it be limited to electrical accidents, as this expert has testified that that is what their background and experience is with.
Okay. And Ms. Catan, did you mean to elicit testimony only with respect to electrical accidents, or do you anticipate going farther afield than that?
The specific incident does involve electricity, but this expert did an entire site inspection involving warning signs, the power lines themselves, and assessed the reaction of the potential worker in this workplace environment. So I anticipate that she will be testifying to that effect.
Ms. Hanselman, do you would you like to voir dire?
No, we raise no objection to her staying on that narrow path.
Okay, so let me just be clear that both sides are in agreement that this expert, this witness will be qualified or accepted as an expert in ergonomics and human factors pertaining to electrical accidents, which may include warning signs and human factors associated with the workplace that we have in this case.
Yes, Your Honor.
Thank you, Your
Alright.
Honor.
Go ahead, Ms. Catan.
Dr. Knupel, can you briefly explain to the jury what opinions you came to?
Yes, it is my opinion that the winery failed to warn Charlie about the high voltage power lines. And because of that, Charlie was not aware of that danger. And this lack of warning is what caused Charlie's death.
And what did you do in preparation for this case?
I completed a site inspection. I reviewed all of the depositions and all of the statements given. I looked through the photographs of the boom lift and the photographs of the accident site. I reviewed the police report and the coroner's report and all of the documents that were produced and exchanged between the parties.
Okay, so let's talk about your site inspection. What did you do during that site inspection?
Well, I looked over the accident scene and I was looking at three main things. First, I looked around for warning signs. Second, I looked at the power lines themselves. And third, I assessed the visibility. And on top of that, I looked over the boom lift or what was left of it at the time.
Okay, so let's break that down a little bit. Let's start by talking about the warning signs. Did you find any warning signs on the property?
Yes, I did.
What kinds of warning signs?
They were warning signs for high voltage.
And where did you see them?
They were posted in all of the wrong places. I found no warning signs on or even near the accident site.
Who do these warn?
These signs are meant to warn a layperson or somebody who had not been trained on safety hazards. So it would have been somebody like Charlie.
What else did you discover about the warning signs on the property?
That there most definitely were not enough signs posted.
Were the signs that were posted enough of a warning for someone who has been inadequately trained on safety hazards?
Oh, absolutely not.
Why not?
Because the likelihood of an accident in that area was significantly higher because the trees were overgrown and partially concealing those power lines. So anybody who had been working in that area would have needed the visible reminder of that potential danger, especially when they're partially concealed.
Well, were there any warning signs on the boom lift?
By the time I arrived for my site inspection, the boom lift had been completely burnt. So I don't know, but it's my understanding that there are typically standard manufacturing warning signs on a boom lift.
And can you explain to us what a boom lift is?
Yes, it is a very big machine. It can weigh up to 16,000 pounds. It's a machine that can be driven, but has a bucket that someone can stand or sit in. And that bucket can be raised up to 50 feet in the air. And it's used to work on a variety of projects high in the air.
So the warning signs on that boom lift, were they enough of a warning for someone who's unaware of the safety hazards?
Absolutely not.
Why not?
Well, because first of all, Charlie would not have known to look at those warning signs. The warning signs on the boom lift like that are not big enough in size to warn a layperson. And second of all, because the boom lift that was used, we have no idea the condition of those warning signs. So we don't know whether they were legible, whether they were worn out, or their condition at all.
Was there anything else in that area that could have warned someone who was unaware of the safety hazards?
No, there was nothing on that site that would have warned Charlie or any layperson of the danger.
Would a high voltage sign be appropriate or even necessary in the area where Charlie died?
Definitely, yes.
Now let's talk about power lines. What did you learn about the power lines?
Well, I learned that they were very hard to see because of how big the trees had grown.
What do you mean?
Well, the trees on that road were growing so much so that their branches began to cover those high voltage power lines.
When did you see those trees?
During my site inspection.
Your Honor, I would like to direct opposing counsel, the witness, and the court's attention to what has been previously marked as exhibits 19 and 21 in the record.
Okay.
Dr. Knupel, do you recognize this?
Yes, I do.
What is it?
These are photographs of the trees and the power lines on the Corker vineyard.
Is this a fair and accurate depiction of the trees and the power lines on the vineyard?
Yes, it is.
Your Honor, at this time, plaintiff moves to enter plaintiff's exhibits 1 and 2 into evidence, striking all prior marks of identification.
That request is denied. I'm going to need the exhibits, since they were pre-marked, I'm going to need them to conform to the pre-existing markings on them. You indicated that they were pre-marked as exhibits 18 and 19 or 19 and 20?
They were pre-marked as exhibits 19 and 20. We can do that, absolutely no problem, Your Honor.
All right, let me turn to the defense. Ms. Hanselman, do you have any objection to the admission of what has been pre-marked as exhibits 19 and 20?
Yes, but for clarification, is it 19 and 20 or 19 and 21?
I'm sorry, I misspoke. It was 19 and 21. My
Okay,
mistake.
yes. No objection to 19 and 21. And again, we would also request that they maintain their pre-marked numbers.
No need to re-request that because I already said that's what I'm going to do. But just for clarity, I need to ask, when you asked the witness about the exhibits, were you looking at 19 and 21?
Yes, I was looking at 19 and 21. I'm sorry, Your Honor, I misspoke.
All right. Exhibits 19 and 21 will be admitted into evidence.
Permission to publish to the jury, Your Honor.
Granted.
Just one moment. Dr. Knupel, do you see these photos?
Yes, I do.
Is there anything different between the lines and the trees at the time that you saw them versus how they appear in these photos?
Yes. So in these pictures, they show much more well-trimmed trees and you can see the power lines a little more clearly. What I saw during my site inspection was very different. The trees were growing much more onto the power lines. So the power lines were much more difficult to see from the bottom looking up.
And when did you conduct your site inspection?
I was there 2 weeks after the accident.
Was there any significance to your timing?
Oh, of course. Well, because this accident involved these trees, I needed to be at the site as close to the accident as possible. We were dealing with trees which can change depending on nature, seasons, timing. It was very important.
Thank you, Mr. Lindsay. You can take the exhibit down now. Dr. Knupel, let's talk about the visibility that you mentioned earlier. Would the danger of those trees be visible to someone who doesn't know about the safety hazards?
Oh, absolutely not. Somebody like Charlie would have been completely unaware of this danger because it would have been functionally invisible to him.
Can you explain what functional invisibility means?
Yes, it's a concept that explains why we don't recognize or pick up on something that might be within our visible field. Our brains are trained in a way to focus on what we know to be dangerous. So if we aren't expecting to see something, it's not in the forefront of our brains because we don't think it's a danger. So in essence, it becomes invisible to us.
Now, does a horizontal versus our vertical vision, does that make a difference at all?
Yes, it does. Because our brain will prioritize things that we see horizontally, because that's typically how we register movement. So danger that is posted above or below is much harder for our brains to pick up.
And how would this affect someone's vision?
Well, Charlie was inadequately trained on safety hazards and he was ascending at the time. So the dangerous power lines were not in his horizontal line of view, which was making it even more difficult for him to register it, not to mention that those trees were partially concealed.
What about our peripheral vision? Does that come into play?
Well, our brain would ignore static or non-moving items in our peripheral vision.
Why does our brain do that?
Again, because they're not moving, our brain doesn't think they pose any threat.
Dr. Knupel, can you give us an example of what functional invisibility would look like?
Yes, of course. So if you think about it like with a snake, for example, if you walk by a snake, you might not realize that the snake is lying there because it's not moving and it's not a danger that you're expecting to walk into. So that snake is functionally invisible to you until it strikes, because only then would you register its threat or the pain. So in essence, Charlie had no warning of these power lines because they weren't moving and he wasn't expecting to encounter that danger.
Thank you, Dr. Knupel. Now, I understand that you reviewed all of the depositions and the documents that were presented and exchanged between the parties in this case. Did you find any indication in those records of Charlie being trained?
Yes, I did. Based on what I read in the depositions, his father and his brother saw him getting trained by an employee on the vineyard. His father saw an employee by the name of Blair Pickus showing him how to move the machine up and down.
Objection, Your Honor. This is mischaracterizes the evidence.
Ms. Katan?
Your Honor, I can re-ask this witness this question and she will not misstate the evidence.
I'm sorry, that objection is actually overruled. Misstates the evidence is not a valid objection to an answer. It's a valid objection to a question, but it's not a valid objection to an answer, so it's overruled.
Dr. Knupel, based off of the records that you reviewed, what is your understanding of the training that Charlie had?
Well, in reviewing all the statements, it's my understanding that Charlie was never formally trained on any hazards of a boom lift, but that he only received a brief amount of training from the employee who says to have lost the keys to the boom lift and that employee who might not have had adequate training himself.
And why do you say that?
Because there's nothing in the record to suggest that that employee, Blair Pickus, or any of the defendant's 70 employees were ever formally trained in boom lift operation. There was no indication that anyone took a course or had any type of certification for the operation of this machine.
Why does that matter?
Well, it matters because the employees were not then clearly trained on the safety hazards. And that means they likely didn't train or warn Charlie about those either. And nothing in the record shows that Charlie was trained on being around those power lines or even about them at all.
Well, how would this type of training contribute to the idea of functional invisibility?
Based on the very little training that Charlie received, this functional invisibility matters. Because of his crash course was not formal training, Charlie was then a layperson. So he had no knowledge of the voltage of the power lines or no notice of the danger. So he wouldn't have cognitively recognized or even appreciated the danger because, again, they were non-moving, he was moving vertically, and the power lines were partially concealed.
What is your understanding of the danger that Charlie was facing?
Well, it's my understanding that he was facing the danger of electrocution by power lines that contained 86,000 volts of electricity.
And to your knowledge, what was the result of this danger?
Well, the boom lift hit the wires and Charlie was electrocuted. The electricity coursed through his body, set him ablaze, and he likely survived for 3 minutes of this electrocution. And to die by electrocution is a excruciating death.
Objection, Your Honor, 403.
In what way? Could you please just elucidate 403?
Yes, Your Honor, this is a bifurcated trial. So while it is necessary to establish that there was harm, as they are elements in today's case, it is not necessary or relevant to go into the extent of that death or how much pain he would have suffered. And it only serves to unfairly prejudice the jury by inflaming their passions and giving him more sympathy, which is not relevant.
Ms. Catan, what's the relevance of the extent of how excruciating it is to die by electrocution?
Your Honor, may I be heard outside of the presence of the jury?
All of these are constructively sidebarred. Of course, we can't actually have a sidebar, but all objection responses are constructively out of the presence of the jury. Go ahead.
Thank you, Your Honor. This is relevant. What is at issue in this case is whether the defendant was negligent. Now, whether the defendant put up warning signs and knowing the extent of the danger and what could happen as a result of that danger on his property directly goes to the extent of how negligent he was as an owner of this property in not putting up warning signs or alerting his employees or anyone living on that residence of the danger that they are facing.
Ms. Catan, that didn't address my question and Ms. Hanselman's point that whether you die an excruciating death from electrocution or whether you just die, do you think that that changes the degree of someone's negligence and the assessment the jury would have to make on that particular question of liability?
Your Honor, I would be happy to strike that portion of the answer out of the record.
All right, so that objection is sustained. And we're back on the record. The jury is to disregard the statement of Dr. Knupel indicating the degree of pain one might suffer from electrocution. The jury is directed that it is not relevant at this time. Please continue, Ms. Catan.
Thank you. Dr. Knupel, after your review of this case, what was your ultimate conclusion?
It was my conclusion that Corker Winery's failure to warn Charlie made him completely unaware of the dangers of these high voltage power lines. Charlie did not expect or to encounter them, did not expect to notice them. And because of that, it's Corker Winery's failure to warn Charlie that was his ultimate cause of his death.
Thank you, Dr. Knupel. I have no further questions.
Thank you. Any cross-examination by Ms. Hanselman?
Yes, Your Honor. Good morning, Dr. Knupel. I want to start by talking with you about whether or not the lines on Mr. Corker's property were in fact visible. So I'm actually going to direct your attention to exhibits 20, 22, and 23, and you'll find those starting on page 111 of your trial packet.
Yes, I see them.
So all three of these are pictures of the road where the accident occurred.
Yes.
And you know this from your investigation.
Correct.
And these are all fair and accurate representations of that scene.
They are, yes, for the time that these photos were taken, yes.
Your Honor, defense moves exhibits 20, 22, and 23 into evidence.
Any objection by the plaintiff?
Yes, Your Honor, I would object to exhibit 23 under 403 as unfairly prejudicial and as not relevant.
I'm sorry, number 23?
Yes, exhibit number 23 on page 114.
Unfairly prejudicial?
Yes, Your Honor, may I be heard?
Go ahead.
This image is unfairly prejudicial to the jury because it would lead them to believe that Charlie was working in the site between the trees where these wires are clearly exposed, but that was not the danger or what Charlie was seeing at the time that he was working on the boom lift. And I believe that this would be unfairly prejudicial to my client and not relevant because what is at issue in this case is where the accident happened, not what this picture is showing.
Any response, Ms. Hanselman?
Yes, Your Honor. Under 403, the evidence would have to be substantially more prejudicial than probative. And in this case, these pictures are incredibly probative. As this witness just testified, these are pictures of the scene where the accident happened. And the visibility of these wires is at issue in today's case. The fact that these are prejudicial to her client alone is not enough because evidence in a trial is inherently prejudicial to the other party. And in this case, the probative value of this outweighs any prejudice.
It sounds like the parties' interpretations of whether this exhibit is adequately demonstrative depends upon further testimony. So at this time, I'm going to overrule that objection. Exhibits 20, 22, and 23 are admitted. Ms. Catan, if you've got further questions on cross-examination, I would expect you to address them at that time with respect to this exhibit. Go ahead, Ms. Hanselman.
Permission to publish exhibits 20, 22, and 23.
Granted.
Now, Dr. Knupel, looking at exhibit 20, you can see the power lines in this picture, correct?
In this picture, yes, but these photos were taken like a year after the accident.
Okay. My question was just that you can see them, correct?
Correct. In this photo, I can.
Now looking at exhibit 22, you can see the power lines in this picture as well.
Again, in this photo, yes, I can.
And now looking at exhibit 23, again, you can see the power lines in this picture.
I can see them in the picture, yes.
Thank you, Ms. Boyle. Now, as you testified on direct, in addition to looking at these pictures to come to your conclusion, you also did an on-site inspection.
Correct.
And after that inspection, you concluded that the lines were not physically obstructed.
They were partially concealed.
Right, but the lines were still visible, correct?
At certain points, yes.
And in addition to the lines being physically visible, as you testified on direct, there were warning signs all over Mr. Corker's property.
They weren't in the right places, but there were warning signs present elsewhere.
So I'm going to turn your attention to exhibit 29, and you'll find that on page 140 of your trial packet.
I'm sorry, which exhibit number was that?
29.
Thank you.
Yes, I see it.
This is a picture of the warning signs that were on Mr. Corker's property.
Yes.
And this is a fair and accurate representation of those warning signs.
Yes, it is.
Your Honor, defense moves exhibit 29 into evidence.
Any objection from the plaintiff?
No, Your Honor.
Exhibit 29 is admitted.
And permission to publish.
Granted.
Dr. Knupel, this sign does indicate that there is a danger of high voltage, correct?
The sign does, yes.
And this was in multiple places on Mr. Corker's property.
On the property, yes, not at the accident site.
And Charles Burns lived on this property for over a year.
That is my understanding, yes.
He was actually driving the boom lift on that property on October 17th of 2018.
He drove it down a service road that did not have any power warning signs.
But you would agree with me in that year that he was living on the property, it is possible that he would have seen one of these signs.
I don't know where he spends his time in that year he spent on the property.
Sorry. Is it your testimony that after living on the property for over a year, he would have never seen one of these signs?
Your Honor. Asked and answered.
It has not been asked and answered. Overruled. Could you please repeat that question, Ms. Hanselman?
Yes. I'm asking, is it your testimony that after living on this property for over a year, that he would have never seen one of these signs?
No, that's not my testimony. It's possible. I just don't know where he spends his time, what he would have seen.
Okay, but that's a yes, that it is possible he would have seen this sign.
Sure, it is possible, yes.
Okay, thank you, Ms. Boyle. Now, turning specifically to the day of October 17th, 2018, you're aware that Montgomery Burns was in the boom lift with Charles.
I am aware of that, yes.
And to your knowledge, Montgomery Burns doesn't have any training on the power lines of the boom lift.
Not to my knowledge.
And to your knowledge, Montgomery Burns didn't receive any additional warning that Charles didn't have.
I do not believe so.
But you're aware of the claim that Montgomery Burns did see those power lines on October 17th, 2018, before the accident occurred.
Yes, but he was only a passenger on the boom lift and Charlie was driving at the time, which goes to my functional invisibility opinion.
Right, but that's a yes, that Montgomery was able to see the power lines.
Yes, he says that he was able to see them.
Okay. So now that we've established that the lines on the property were physically visible and that there were warning signs, I want to talk about the access to the boom lift. Now, you're aware that Charles Burns actually had to break into a locked barn to get to the boom lift.
I'm not entirely aware of that. I read that that's what the defendant says, but I don't have any information beyond that.
Well, but you did review all the depositions, correct?
Correct.
And Phoenix Burns never claims that he saw it out the day of the accident.
No, he didn't say much to that.
And Montgomery Burns didn't claim that they accessed it out on the property the day of the accident.
He didn't say where he was when they got on.
But rather, Blair Pickus has stated that he did return it to the locked barn the day before.
I believe what Blair Pickus said was that he usually does, but he doesn't know exactly what happened that day.
Right. So you're not aware that Blair Pickus stated that he returned it to the barn?
No, I'm aware that he said, I usually always put it back in the barn, but I think he said he couldn't remember exactly that day.
Okay. Well, so let's talk about some other factors that may have contributed to the accident in this case. Now, just to be clear, you're not actually trained on boom lift operations.
No,
But you're still aware that there's just some common sense things that you should and shouldn't do when operating a heavy machine like this.
yeah, of course.
Like, for example, you should always drive the recommended speed.
I'm sure that is something to do, yes.
And you would agree that it's common sense to wear corrective lenses if you need them.
Depending on your prescription or anything, sure, yes.
Yeah. But you just agree generally corrective lenses help you see better, right?
I would agree, yes.
You'd also agree that it's not reasonable to operate a machine like this after drinking alcohol.
Generally, no, but there are, like, depending on amounts and stuff, there are legal limits, but generally I would agree, no.
Well, but now looking at the day of the accident, you're aware of claims that Charles was driving over 15 times the recommended speed.
I don't know that I'm aware that it was 15 times the recommended speed.
Well, you reviewed all the documents in this case,
Yes, I did.
and that would have included a specification sheet for the boom lift.
Yes,
And the recommended speed is 0.68 miles per hour, correct?
I would have to relook at the number, but that could be right.
Okay, and you're aware that there was an activity report in this case, correct?
Yes, I'm aware.
And that stated that Charles was driving 15 miles per hour before the accident happened.
On October 17th, at one point, the boom lift was going 15 miles an hour, yes.
Yet you rejected this speeding as a potential cause of the accident?
No, I just said I didn't know that that was 15 times the number.
Oh, so you didn't even consider the fact that he was speeding and coming to your conclusion then?
No, of course I considered everything. It was just not the cause, in my opinion. The cause was the concealed lines and the failure to warn.
Right, so that's a yes then, that you rejected speeding as a cause of this accident?
I rejected it as the ultimate cause. I considered all factors.
Okay, well, you're also aware of claims that Charles wasn't wearing his contact lenses.
I read that Monty said that, yes.
But again, you rejected that as a potential cause of the accident?
Well, I had no information about the strength of his prescription, any sort of requirement to wear when driving. Monty did not elaborate on anything like that. It did not weigh into my final opinion.
So without even obtaining any information about his prescription, you rejected that as a cause of the accident?
It was not part of my ultimate conclusion. Again, I didn't reject it. My ultimate opinion was that the failure to warn and the poor training was what the ultimate cause.
Okay, well, and again, you're also aware of claims that Charles was seen drinking wine before operating this boom lift.
Yes, I read that Monty again said that, but there was no indication to show how much he had been drinking. We have no information about blood alcohol content, toxicology, so he wasn't.
So without even obtaining any of that information, you rejected his drinking as a potential cause of the accident?
Again, I didn't reject it, no. It just wasn't the ultimate cause because there were much more dangerous things like no warning signs and poor training.
Right, and Dr. Knupel, I'm not asking about the warning signs and the training right now. I'm just asking about the drinking. And it sounds like you're saying that you did not consider his alcohol consumption in coming to your conclusion. Is that correct?
No, I considered it. It just didn't have as much weight as the other factors.
Right, so you rejected him drinking alcohol as a potential cause of the accident.
No, it was a
Your
potential.
Honor, badgering the witness.
Ms. Hanselman?
Yes, Your Honor, I'm just trying to get a straight answer from this witness on whether or not she actually considered this information in coming to her conclusion. She's an expert and has given some very specific opinions. And so it goes directly to the credibility of her investigation, whether or not she considered a factor such as drinking alcohol in this case.
Ms. Katan?
Your Honor, this expert has already answered that question more than once. She said that she had considered it, and she gave the weight of that consideration in her investigation. So she has asked this question and she has answered this question.
So is your objection about badgering, which is not a legal objection, badgering, is it based upon asked and answered? Is it based upon argumentative? What is it based upon?
It is based upon the fact that this opposing counsel will not move on from a question that has been answered. I believe that she's badgering the witness, but in response to her prior response about not getting a clear answer, I am highlighting the simple fact that she has gotten a clear answer and is continuing to badger the witness beyond that.
Okay, well, without expressing any opinion as to whether I agree with both of you or disagree with both of you, that objection is overruled. Ms. Knupel, Dr. Knupel, the question was, I believe the question that was asked was about whether you had rejected the consumption of alcohol as a potential cause of this accident. What is your response to that?
No, I did not reject it as a potential cause. It just didn't carry the weight to the ultimate cause for me.
Ms. Hanselman, you can continue.
And so, Dr. Knupel, I just want to be clear here that without even investigating how much he had had to drink, you did not consider it a cause of the accident.
Correct. I reviewed the coroner's report and there was no toxicology report. So beyond that, I reviewed what was in the record.
Okay. No further questions.
Thank you. Ms. Katan, any redirect?
Brief, Your Honor. Opposing counsel showed you pictures of wires. Can you tell us about them?
Yes, the photos that I was shown were, I believe, photos of the power lines on the Corker property, but the photos were taken about a year or so after the accident itself, and they were taken of the opposite side of the road, the vineyard side of the road. And in my review of the record and all the depositions, Monty Burns, who was present with Charlie at the time of the accident, stated that those exhibits were photos of the trees and the power lines, not at the scene of the accident, but rather on the opposite side of the road, and they're showing entirely different power lines and entirely different trees.
Why could Charlie not see the power lines if Monty could?
Well, that's my entire the concept of functional invisibility. So Charlie would have been focusing on driving the boom lift, trimming the trees, using his saw and operating the machine, where Monty was just in the boom lift. So he had opportunity to look around. And again, with functional invisibility, when you're focused on one thing, other non-moving things become invisible to you.
In your review of all of the documents in this case and in your site visit, was there any evidence of tampering with the barn?
No, I saw no evidence that Charlie tampered or that the barn had been tampered with. that there had been any sort of destruction or vandalism in any kind, or even any information beyond Blair saying that it would have been locked.
No further questions.
Is this witness excused? Ms. Katan, is this witness excused?
Yes, I'm sorry.
All right. Thank you for your time and testimony, Dr. Knupel. All right, is that the conclusion of the plaintiff's case?
Yes, Your Honor, the plaintiff's rest.
All right, thank you. Before we begin the defense case, I'm just going to take a moment here.
The defense would actually request a brief 5-minute recess before beginning our case in chief.
Okay, how does that sound to the court reporter? All right, let's do that then. It's 10:34 right now. I'm going to go back on the record at 10:39. Go ahead and put yourself on mute so that I can't hear everything that's going on in your background. Thank you.
Thank you.
All right, we're back on the record at 10:39 a.m. I see all counsel present as before. We're about to commence with the defense portion of the case. Does the defense have a witness to call?
Yes, Your Honor. The defense calls Dr. Eric Faustner to the stand.
All right. Dr. Faustner, you are aware that you are already under oath?
Yes, I am.
All righty then. And then so Ms. Boyle, you'll be commencing this direct examination?
Yes, thank you.
All right, please proceed.
Dr. Faustner, good morning. Please state your name and spell your last name for the record.
Hi, my name is Dr. Eric Faustner, and that's spelled Faussner.
Dr. Faustner, how are you involved in this case?
I am the engineering expert. I was retained by defense counsel for my opinions on the theft of this heavy machinery that resulted in Charles Burns's death.
And I want to ask you about your experience first. What experience do you have in the engineering field?
I have both a master's degree in electrical and mechanical engineering from the University of the Pacific, and I have a doctorate in ergonomics from Berkeley. But I've also investigated electrical accidents, some of which that have electrocutions with power lines, just like in this case.
Great. What do you actually do for a living?
I actually own my own consulting company. It's called Insight Tech Incorporated, and it's just a safety consulting firm that investigates workplace accidents, and we do safety evaluations.
In your investigations of electrical accidents, have you come across boom lifts before?
Yes, I've analyzed many boom lift electrical accidents before.
How familiar are you with the operation of a boom lift?
Very familiar. I'm both trained and certified on operating boom lifts. And because boom lifts operate generally in the same way, the operations of the boom lift I was trained on is comparable to the boom lift in this case.
And what materials do you typically review in investigating these accidents?
So I review information about the site and the safety requirements. In this specific case, I reviewed all the documents, the photos, the police report, the autopsy report, and I also looked at an aerial view of the property and saw the remains of the boom lift.
What do you do with all that information?
I look at it all and I determine whether or not the precautions that needed to be in place were in place. And that's exactly what I did in this case.
Are your opinions based on reliable principles and methods?
Yes, they are.
Do other experts in your field use those same principles and methods?
Yes, they do.
Your Honor, defense moves to tender Dr. Faustner as an expert in electrical accidents and boom lift operations.
All right, on the subject of electrical accidents and boom lift operations, any objection from the plaintiff?
No, Your Honor.
Okay, and would you like to voir dire?
No, Your Honor, we would not.
All right, Dr. Faustner will be accepted as an expert in electrical accidents and boom lift operations. Go ahead.
Certainly. Dr. Faustner, what is your opinion about this case?
My opinion is that Cindy Corker took all the reasonable precautions. I mean, the power lines were open and obvious. There were warning signs on the power lines and on the boom lift.
and the boom lift was locked in the barn where it was supposed to be. Mr. Corker, he couldn't have anticipated this break-in and these unfortunate actions. Unfortunately, this accident was caused by Charles's actions himself.
Now, I want to break that down by talking about the power lines first. We've heard quite a bit about power lines today. Do you know if the power lines on Mr. Corker's property were visible?
Yes, they were open and obvious. All you had to do was look up to see them.
Besides looking up and seeing them, was there any other way to know that there were power lines on the property?
Yes, there were signs posted on the lines around the property, and they said danger, high voltage.
Your Honor, permission to display what's been previously entered as Exhibit 29.
Granted.
Dr. Faustner, were these warning signs enough to warn someone of the dangers of power lines on the Corker Wines property?
Definitely. I mean, like I said earlier, the power lines were already open and obvious, so these signs are more than enough. And there's additional signs on the boom lift to warn the operators who might come close to lines.
Would Sidney Corker have any reason to do anything more with the power lines?
No, absolutely not. Even though these power lines are on his property, they're owned, installed, maintained, operated all by the utility company that puts them up and owns them. Mr. Corker is not a trained electrician, so he should not be dealing with them.
Thank you, Ms. Hanselman. Dr. Faustner, are you familiar with the term functionally invisible regarding power lines?
Yes, I am familiar with that concept, but I don't think it applies in this case. I mean, we've had power lines for over 100 years. We drive cars at high speeds every day, and we can recognize static objects in our vision. So it's just not as relevant in this case. We know that they are dangerous. They've been around for so long.
In your opinion, were the power lines a danger to someone on the Corker Wines property?
Well, power lines are dangerous, but these lines were so high in the air that someone walking or driving on the property had no risk of getting too close to them. Even if someone could reach those lines, they were sufficient warnings in place.
Now that we've discussed the warnings, I want to turn our attention to the boom lift. You mentioned you have investigated boom lift accidents before. Is a boom lift dangerous to operate?
Yes, they can be very dangerous if they're not used properly or if they're used by someone who's untrained. That's why training is actually required by law to operate boom lifts.
Is it possible for someone to operate a boom lift without any training?
Yes, someone could figure out how to turn it on. I mean, there's a manual on the boom lift, and once you actually have the boom lift on, the controls are pretty simple and intuitive. And if you didn't have a key, someone who really wanted to drive it could just shove a screwdriver in the keyhole to turn it on. But just because you can turn it on and, use the controls does not mean that you're operating that boom lift in a safe manner.
What do you mean by operating in a safe manner?
Well, to operate a boom lift in a safe manner, you need to know how to operate it. And by that, I mean, you need to know how fast you can go on that boom lift. If the bucket's raised even a little bit, or if it's raised all the way, you need to know how to turn it, the turn radius, how to be safe during that, how much weight you can hold, how much weight the bucket can hold. It's just very much a lot of information.
Dr. Faustner, turning your attention to pages 115 through 117 of the case packet. On those pages, you'll find exhibits 24 and 25. Will you let me know when you're there?
Yes, I have them in front of me.
Do you recognize exhibit 24?
I do. This is the standard specification sheet of the boom lift, the Genie Z4525 JDC. This has all the operating information about the boom lift, and I reviewed it in preparation for this trial.
And do you recognize exhibit 25?
Yes, I recognize this as well. This is the computer-generated activity report for the boom lift on Corker Wines, actually, and it just details when the boom lift is powered on and off, how far it's being driven, and how fast it's going when it's being driven.
Are both of these documents fair and accurate representations of the documents you reviewed?
Yes, these are the exact documents I reviewed for this case.
Did you rely on these documents in coming to your conclusions?
Yes, I did.
Your Honor, defense moves to admit exhibits 24 and 25 into evidence. And we'd also like to direct the court's attention to page 83 of the case packet, which has the custodian of records for these documents, and stipulation number 5, which says that this custodian of record is self-authenticating under Rule 902.11.
All right, you've just referred me to 3 different things. Just give me one moment.
Of course.
Okay, Mr. Lindsay, do you have any objection to the admission of exhibits, what has been previously marked as exhibits 24 or 25?
No, Your Honor, no objection.
Okay, hearing no objection from the plaintiff, exhibits 24 and 25 are admitted in their entirety.
Your Honor, permission to publish to the jury.
Granted.
Dr. Faustner, earlier you mentioned speed is important when operating the boom lift safely. How fast should it be driven?
So with the bucket down, as you can see in this exhibit at the very bottom of the picture, you can go 2 to 4 miles per hour, which is perfectly safe. But if that arm is extended up at all, and you can see in this picture that it extends up to 50 feet, even if it's just extended just a little bit, you should not be driving faster than 0.68 miles per hour.
Ms. Hanselman, if you could zoom in on exhibit 24. Dr. Faustner, is it recommended for someone to drive the boom lift with the bucket raised up?
No, only for short distances. For any longer distance, you're going to need to actually lower that bucket that you can see in that picture and put it on a flatbed to transport it. These boom lifts are big, so they're difficult to transport. So in the middle of a project, it's common practice in the industry just to leave it at the site where you're working.
Now, I want to talk about whether Charles Burns was operating the boom lift safely. Are you aware of how high the basket was when Charles Burns was driving it?
Yes, the bucket was raised. So if you look on exhibit 24, you can see that it was raised up towards the power lines. So they should have only been going 0.68 miles per hour for safety reasons and paid special attention to overhead objects.
Turning your attention to exhibit 25, how fast was the boom lift generally driven on the Corker Wines property, according to this report?
Yes, you can see here that it was usually driven between 2 and 4 miles per hour, which is perfectly safe.
And Ms. Hanselman, if we can zoom in a little bit. How fast was Charles Burns driving it on the day of the accident?
Yes, you can see here that they were driving actually 14 and 15 miles per hour. I mean, that's just driving recklessly and out of control.
Ms. Hanselman, if we can put red boxes around those speeds. Thank you, Ms. Hanselman. Dr. Faustner, could speeding have contributed to the accident in this case?
Absolutely. Speeding increases the chance of hitting an overhead object exponentially.
Are you aware of claims that Charles was not wearing his corrective lenses on the day of the accident?
Yes, he was not wearing his corrective lenses, his contact lenses, or glasses for that matter.
Could not wearing his corrective lenses have contributed to this accident?
Absolutely. I mean, to operate a boom lift properly and safely, you actually have to see what's going on around you. I mean, you need to see the objects around you, above you, and you actually need to see the control panel. So corrective lenses or glasses would have been absolutely important in this case.
Are you aware of claims that Charles Burns was drinking alcohol on the day of the accident?
Yes, I am.
Could drinking alcohol have contributed to this accident?
Definitely. I mean, alcohol impairs your ability to operate a boom lift, just like it impairs your ability to drive a car. Driving something so complicated, sophisticated, I mean, having alcohol even impair your ability just a little bit would be incredibly unsafe and contributed to this accident so much.
No further questions.
Thank you, Ms. Boyle. Mr. Lindsay, do you have cross-examination?
Yes, I do, Your Honor. Dr. Faustner, you own a company?
I do.
Insight Tech Incorporated.
Yes, that's the name.
And you provide expert witness testimony
I do, yeah.
in trials
Yes, just like today.
and in depositions.
Yes, just like in this case.
It's a stream of income for your company.
We do other things. We do like safety evaluations and consulting. So, I mean, it's not our only stream of income, but yes, we do make money off of these if that's what you're asking me.
And you personally have testified over 200 times.
Yes, I have.
80% of those times were for the defense.
I think that's the amount of numbers, but most of my clients followed me. So I just, go where my clients take me. If they're defense, then they're defense.
And your client today is a defendant.
Yes, that's true.
And you're paid for your testimony.
Yes, I mean, I am an expert witness. I'm very busy. I have a degree in electrical and mechanical engineering and a doctorate in ergonomics. So I would expect to be paid for my expert testimony.
Thank you, Your Honor, or thank you, Doctor. Let's talk about one of the ways you prepared for this case. You became certified in boom lift operations
Yes, I did.
for the first time.
Yes, I've had a lot of boom lift accidents before, but I mean, this case, I really wanted to know I had everything right. So I made sure that I went and actually got boom lift certified for this case.
I appreciate the level of detail, Doctor, but a yes or no would suffice. You were trained through the certification after you were retained for this case.
Yes,
And in that time, you learned everything one needs to know to safely operate a boom lift.
that's true.
You learned how to start a boom lift.
I did.
How do you start one?
Well, you started by putting the key in the ignition. Oh, are you actually going to count? Here, let me make sure I've got that all right for you. One moment. I'm just going to review my notes that I took during my class, so I make sure I get that right for you since I brought them with me today. One moment. So you turn them on. It's kind of complicated actually to turn them on. I'm sure you're aware. You actually have to, do a lot of.
Objection, Your Honor, calls for narrative.
Overruled.
So yeah, it is pretty complicated. I mean, you have to do things with the control panel and with the foot pedal at the same time. You have to turn this switch, and if it goes over to a little just too far, then that has the potential to, not turn it on if you even turn it on just a little bit over towards the blue. And you have to make sure that.
If I may help you out, you insert the key.
Yes.
You turn
true. Yeah,
you pull the e-stop button.
that's right.
You then go to the basket
Yes.
and you engage the safety toggle.
Yeah, it sounds like you know exactly how to turn it on.
And you do that without pressing down on a foot pedal.
That's absolutely correct.
And then you hit a foot pedal.
Yes, you do.
So I think I got 6 or 7 steps there.
Absolutely. You're absolutely correct.
You'd agree that's a very specific set of steps that one needs to go through to start a boom lift.
6 steps. I mean, yeah, 1, 2, 3, 4, 5, 6, pretty specific, but you can learn it all in the manual as well. I was just lucky enough to actually get certified.
And Doctor, in your review of this case, you didn't see a manual or find any evidence of a manual on the boom lift that Charlie died on.
Could you please, I actually reviewed a manual. There was the ashes of one in the burnt boom lift.
There were ashes on the boom lift, but those ashes were never indicated to be a manual.
No, like I said, they were burned to ash.
You learned how to drive a boom lift in this class.
I did.
You learned how to raise the arm up and down.
I did.
And you learned about safety hazards.
Yes, that was part of the training.
You learned about tip over hazards
Yes, I did.
and overhead power line hazards.
I learned about that as well.
And you learned that in comparing the two, overhead power lines are the more dangerous hazard for aerial operations.
Tipping hazards are actually more common, but yes, electrical hazards, they do cause accidents.
But to answer my question, Doctor, the more dangerous of the two you learned in your class was overhead power line hazards
That's correct.
because they're the most lethal.
That's correct.
In fact, you're not supposed to come within 20 feet of a power line on the type of boom lift that Charlie was killed on
Yes, that's true.
because it's made of metal.
They are made of metal.
It conducts electricity.
Yes, they can be potential conductors.
Now, doctor, you came to the opinion that Charlie didn't have any training or expertise in heavy machinery
That's true.
because he didn't know how to safely operate the boom lift.
I'm sure he didn't have any formal training on this boom lift.
He didn't have a OSHA certification.
No,
He didn't have the legal certification that you have,
no, he didn't.
but he was able to start it.
Yes, I think that it's pretty easy to start if you just read the manual and follow the 6 steps that you outlined for us.
But doctor, to answer my question, Charlie started this machine.
He did start it, yes.
He went through all of the steps.
Yes, he did.
He drove it.
He did drive it. Once you actually get the boom lift on, it's pretty easy to control.
But he raised the arm up and down.
Yes, if you look at the control panel, there's just an up and down arrow that shows you how to do it.
Doctor, again, I would appreciate yes or no answers for these questions.
Of
He
course.
was able to drive it,
He was, yes.
but he didn't know how to safely operate it
No,
because he didn't have proper knowledge of the safety hazards.
yes,
You had a qualified instructor in your course.
I did.
You'd agree that the quality of the instructor determines the outcome of the quality of the training.
I actually think it's determined by how well you pay attention in the class and how much you take from it. I mean, I was taking extensive notes and took very close attention to everything I was learning.
Doctor, is your testimony here today that the quality of the instructor does not have influence over the quality of the training?
No, that's not what I'm saying. I believe that you asked me whether or not it affects the quality of the training. And I think that plays a huge part, and so does your ability to understand what you're being taught.
Let me rephrase the question for you, doctor. The quality of the instructor impacts the quality of the training.
Correct.
Now, in this case, you read the depositions in this case.
I did.
You read that Charlie was seen near the boom lift with the defendant's employee.
Yes, he was seen near the boom lift with the defendant's employee.
Blair Pickus.
Yes, Blair Pickus.
And Blair Pickus was moving the machine up and down.
Yes, he was.
And you never checked whether to see Blair Pickus was legally certified to operate this machine.
No, I didn't check that, but I know that Corker Wines has never been in trouble before for anything, so I'm sure they're OSHA compliant.
So that's a no.
That's a no, yeah.
So you didn't check to see whether anyone on this property was OSHA compliant or legally certified to drive this machine?
No, I didn't think it was necessary.
Doctor, let's talk about something you said in your direct, or you were asked about in your direct exam. You talked about, or excuse me, you mentioned that Charlie was affected by not having contact lenses or glasses.
Yes.
You didn't review any material in this case that told you what kind of prescription Charlie had.
No, but in the same way of driving a car, they put that sort of thing on your driver's license where you need to be able to have your corrective lenses to legally operate a car. It's the same with this. I mean, you need to be able to see what's around you.
So that's a no.
That's a no. I mean, it doesn't matter what his prescription is. He should have been able to see correctly.
Doctor, let's move on. You testified that there was a break-in at the barn.
Yes. I didn't say a break-in. I said a theft.
You didn't review any evidence that suggested that the barn was broken into.
No, and I never claimed that.
You know that other people have testified here today that the barn was locked.
Yes, I've heard that.
Finally, doctor, let's discuss another opinion you came to in this case. You are of the opinion that these power lines were open and obvious.
That's absolutely correct.
That anyone with eyes could see these lines.
Yes.
But you never conducted a site visit in this case.
No, I didn't think it was necessary. I had everything I needed given to me to review for the case today.
You didn't see the barn with your own eyes.
No, I didn't think it was necessary.
You didn't see the power lines that killed Charlie with your own eyes.
Well, I saw them in the aerial view and the pictures that I reviewed. So yes, my eyes did see the power lines.
So instead, you reviewed photographs.
I did, yes, which is standard. Yes.
Absolutely. Photographs taken a few months before your deposition.
Correct.
approximately a year after Charlie died.
I think that's the timeline. Yeah,
These are pictures taken from the road of the power lines
that's true.
to document what the power lines look like.
Yes,
You reviewed Monty Burns' deposition in this case.
I did. Yes.
He stated, or excuse me, he reviewed the photos that you reviewed in this case.
He did.
He compared them to what the power lines looked like to him on the day Charlie was killed.
Yeah.
He stated that the photos you relied on had fewer leaves in them than the trees on the day that Charlie was killed.
Yes. He said that.
You have no knowledge of what the trees actually looked like on the day Charlie was killed.
That's not true, actually. In my case, I did review a picture in a news article that had the trees from just the day after. So I actually do have a pretty good idea of what they looked like, and they were still very visible in that as well.
Doctor, you don't know exactly where on that stretch of road Charlie died.
That's true. I wasn't there.
So you don't know that this photograph you referenced is where Charlie died.
I believe it says that that is where Charlie died, but we can just agree to disagree.
I'm sorry. No one's agreeing to anything. This is testimony.
Doctor, I'll ask you one more time. You don't know exactly what the trees looked like at the spot where Charlie was killed on the day he died.
No, not on that exact day.
Thank you. No further questions, Your Honor.
Thank you, Mr. Lindsay. Any redirect from Ms. Boyle?
Briefly, Your Honor. May I proceed?
Yes, go ahead.
Dr. Faustner, is it possible for someone to review a manual to turn on the boom lift?
Absolutely. I mean, the manual in any boom lift is just right there in the compartment where you keep it. You just really need to open it and follow the steps 1 through 6, and you get the boom lift on pretty easily.
Is there a difference between turning a boom lift on and operating it safely?
Yes, like I've said, there are so many things that you need to be able to be aware of and know about that boom lift. Just because you can get it on does not mean you're operating it safely.
And the materials you reviewed, were those materials enough to provide you the information you needed to come to your conclusions about the visibility of the power lines?
Absolutely. I have testified, as they said, over 200 times. If I felt I needed to do a site inspection, I would have done it, but everything I needed was provided to me.
No further questions, Your Honor.
Okay, thank you.
We'd ask that this witness be allowed to step down at this time.
Hey, Dr. Faustner, thank you for your time and testimony. You are excused. Let me just take a 90 to 120 seconds for our shorthand reporter and also to give me an opportunity to just review my notes for just a moment.
Okay, thank you, Your Honor. My name is Shai Stevens. I am your third and final reporter for the day. Again, just to reiterate, my job is to capture the record. If at any time I cannot hear or understand what is being said, I will interrupt briefly for clarification of the record. That is all.
Thank you, Ms. Stevens. All right, we're still in the defense case here. I see all counsel present. Let's go ahead and have the defense's next witness.
Yes, Your Honor. The defense calls Sydney Corker to the stand.
Okay, Mr. Corker, you are already sworn to tell the truth. You are under oath, and go ahead, Ms. Hanselman.
Good morning, Mr. Corker. Can you please introduce yourself and spell your last name for the record?
My name is Sydney Corker. The last name is Corker.
What do you do for a living, Mr. Corker?
I am the owner and operator of Corker Wines.
And what exactly does that entail?
Well, at Corker Wines, we do everything from growing the grapes to harvesting them to distilling and bottling the wine.
How big of an operation is that?
I mean, we're not the biggest operation in the Valley by any means, but we've grown over the years and we have about 70 employees now.
Mr. Corker, are you aware of the events that took place on your property on October 17th of 2018?
Yes, unfortunately, I am. That was the day that Charles Burns took my boom lift and unfortunately ran it into a power line, bringing about his own death.
I want to help the jury understand how that accident happened. Can you start by explaining for us how you know the Burns family?
Yeah, so about a year before Charles's death, his father came to me and was looking for a place to live. I had an open house available on the property, and I could tell he was a single father that needed a place to live, so I agreed to rent him out that house.
Well, and you mentioned that that house was on your property. So were you having the Burns family work for you as well?
No, absolutely not. They just needed a place to stay, and I gave them a place to stay. They were just tenants. I have plenty of employees to do the work around the property.
Okay. Well, since the Burn family was living on your property, I want to talk about any concerns you may have had with the power lines on your property. Now, before the accident, were you aware that you had power lines on your property?
Yeah, I mean, all you have to do is look up and see them.
And prior to the accident, did you know that power lines were dangerous?
Yeah, I just thought that was common sense.
And is there any way for someone who's maybe a little less familiar with your property to know about the danger of these power lines?
Yeah, aside from looking up and seeing them, there's warning signs on just about every other pole.
And now the Burns family was living on your property where you have these power lines. Did you have any concerns about their safety?
In regards to the power lines, no. I mean, the power lines are way up in the air, like dozens of feet up in the air, and the only way you could even come close to them is something like a boom lift.
Well, because of the additional risk of the power lines when on something like a boom lift, I want to talk about any precautions you may have taken with your boom lift. Now, who's authorized to use your boom lift?
Just a select handful of employees that I've allowed to use the boom lift.
Well, you mentioned earlier that you have over 70 employees. How did you select just this small handful?
Well, you see, the boom lift isn't a toy. It's a dangerous, heavy piece of machinery. So I selected only the employees that I felt were responsible enough and that I could trust to use the boom lift, and provided them the training to operate it.
And just generally, what does that training entail?
The training entails everything from how to start the boom lift, how to drive the boom lift at a safe speed, how to use a spotter when using the boom lift. It's mostly safety protocols.
Well, so now turning your attention over to Charles Burns, was he one of the individuals that you allowed to use your boom lift?
No, not at all. Charles wasn't an employee.
Well, and did you provide him any training on how to use the boom lift?
Absolutely not. Like I said, he wasn't an employee, and I only let even my most trusted employees use it.
Okay. Well, now, since Charles Burns wasn't trained and he wasn't allowed to use your boom lift, I want to talk about whether he had access to your boom lift. So how often do you actually use the boom lift?
I mean, just a couple times a month, maybe. There's the occasional roof that needs fixed, the occasional tree that needs trimmed. No more than a couple times a month.
And is it ever left out on the property?
No, you see, it's an electric boom lift, so it has to be kept in the barn. I think, occasionally the employees will leave it between shifts, but for the most part, it has to go in the barn.
So I'm going to direct your attention to Exhibit 18, and you're going to find that on page 109 of your trial packet.
Okay, I've got it.
What is Exhibit 18?
This is an overhead view of my property.
And is this a fair and accurate representation of your property?
Yeah, it appears to be.
Your Honor, defense moves Exhibit 18 into evidence.
Any objection, Ms. Catan?
No, Your Honor.
Exhibit 18 is admitted in evidence.
And permission to publish?
Granted.
All right, so Mr. Corker, looking at Exhibit 18, where is this barn that you mentioned in relation to the Burns home?
The barn is that building in the yellow circle there. And the Burns home is the building in the middle of this photo. So it's about 2 fields away from the barn.
And we're going to mark that house with a blue circle. Is that correct?
Yeah, that's the Burns residence.
Okay. And so who has access to this barn that's on your property?
Just employees, but specifically only Blair Pickus and myself have keys.
And did Charles Burns have permission to go into this barn?
No, Charles wasn't an employee. He had no reason to go in the barn.
Was there any reason for anyone in the Burns family to go over to your barn?
No, not at all. None of them were employees. I just rented them out a house.
Okay, thank you, Ms. Boyle. And Mr. Corker, how often are you actually on your property?
I'm there all the time. I live on the property. I work on the property. I'm pretty much there 24/7.
And on October 17th of 2018, did you see your boom lift left out on your property?
No, I didn't.
Had you ever seen Charles Burns wandering around your property where he shouldn't be before?
No, I haven't ever seen Charles wandering around.
Did you ever see Charles Burns go into your barn?
No, I have not seen him go into my barn.
Had you ever seen him use your boom lift before?
Absolutely not. He would have gotten more than an earful if I'd seen that.
Did you have any reason at all to believe that Charles would be able to drive your boom lift?
No, I mean, first of all, you need a key to start it, or at least so I thought. And even if he was able to access it, I didn't think he'd even be able to turn it on.
Thank you, Mr. Corker. No further questions.
Thank you, Ms. Hanselman. Cross-examination by Ms. Catan.
Yes, Your Honor. Mr. Corker, I want to talk about your boom lift. It's used by your employees.
That's correct.
And in your own words, this is a dangerous piece of machinery.
Yeah, it absolutely is, as has been evidenced.
It shouldn't be driven by just anyone.
No, I mean, case in point today.
It shouldn't be accessible to just anyone.
No, that's why we lock it in the barn.
And you have 70 employees.
I do have 70 employees.
And only a handful of them have your permission to use the boom lift.
That's correct. Only the employees that I believe are responsible enough to operate it and that have received training.
Yes, and in your own words, these are your most trusted employees.
Most trusted to use the boom lift, yeah.
Can you name that handful of employees for us today?
Yeah, I can. There's Blair Pickus, Chris from processing, Rodrigo from maintenance, and Juan.
4 employees.
That's less than a handful.
Less than a handful. Mr. Corker, you are ultimately responsible for your employees.
Yes, their safety is my responsibility.
And they all report to you.
Well, as you mentioned, it's a fairly decent operation. There's 70, so there's a chain of command, but I guess you could say I'm at the top.
So your employees don't always report to you.
Not directly, no, but things get to me.
I'll move on. Mr. Corker, After your employees use the boom lift, they put it in your barn.
Yeah, it's an electric boom lift, so it has to charge.
And that barn, it's locked.
That's correct. Yeah, only myself and Blair Pickus have keys.
But your employees don't always put the boom lift in your barn.
I mean, not after every time they use it. Sometimes they'll leave it out as they switch between shifts or, eat lunch.
Right, they leave it out
Yes, that's what I said.
without any supervision.
I suppose so.
On your property.
Yeah, it's only allowed to be used on my property.
And you don't see it being left out like this. You don't see any problem with this.
Is your question whether I saw it or whether there's a problem?
You don't see any problem with your boom lift being left out.
It's seems pretty standard. It's not left out, for days and days. It's just for between shifts.
Mr. Corker, you just mentioned that you were around your property almost 24/7.
Yeah, I live there, work there. It's beautiful. So.
And that you would have seen Charlie if he was operating this boom lift.
I mean, no guarantee, but if I did, like I said, he would have received more than an earful from me.
Right. Well, you didn't see Charlie on the day of the accident.
No, unfortunately, I wasn't able to stop him.
And this accident occurred in the middle of the day.
It was about 3:30 in the afternoon, I believe.
Mr. Corker, we just mentioned your employees. Blair Pickus is one of your employees.
That's correct.
He has some experience as an auto mechanic
Yeah.
and only general experience in maintenance.
Yeah, sure.
But Blair helps to oversee your property.
Yeah, Blair, like I said, he's one of my most trusted employees.
He helps to maintain your property.
Yeah, he oversees a lot of the harvesting and a lot of the operations.
Part of maintaining the property will require the use of a boom lift.
Yeah, like I said, we use the boom lift a couple times a month to repair the roof, trim some trees.
Mr. Corker, is that a yes?
Yeah, we use the boom lift.
And anyone using the boom lift, to your own words, has to be fully trained.
Yes.
Maintaining the vineyard includes trimming its trees.
Correct.
And you have trees that run along the service roads of your property.
Yeah, there's trees all around the property.
Power lines also run along those same service roads.
Yes, they do.
And the trees can grow over the power lines if they aren't trimmed.
Yes, that is possible.
You asked Blair to trim the trees on your property.
I did. Yeah, that's what he was doing the day before Charles died.
Right. You asked him to do just the day before Charlie died.
Correct.
And you're aware that Blair never finished the job.
No, because the next day Charles took our boom lift, and unfortunately, we didn't have a boom lift to complete the job the next day.
Mr. Corker, my question was regarding that day. On that day, you're aware that Blair never finished the job. Is that correct?
No, it was a large job. He didn't finish it.
Mr. Corker, Blair is your good friend.
Yeah, I think Blair's a great guy.
In fact, he's been your good friend for about 20 years now.
Yeah, we've worked together quite a while.
Right. He's worked for you actually for over 11 years.
Yes.
And the day after Charlie died, Blair came straight to your property.
Yeah, he was concerned.
Yes, he came to visit you.
Yeah.
Objection, relevance.
Ms. Catan, what's the relevance of this question that he came to visit him?
Your Honor, this goes to the credibility of the witness, whether Blair and the owner of this property had an opportunity to speak before giving a deposition, before giving an official statement. That goes to the credibility of this witness today and all of the testimony that he's giving us.
Ms. Hanselman, do you have a response to that?
Yes, Your Honor, she's inquiring into events that took place after the accident, and this does not have any bearing on what Mr. Corker did before the accident and whether or not that was negligent.
And did Mr. Pickus testify yet in this trial?
Yes, constructively pursuant to stipulation 12, he would have testified first.
And he testified consistently with his deposition?
That's correct.
And this meeting that is being inquired into happened before either the deposition of Mr. Corker or Mr. Pickus?
Yes, Your Honor.
Ms. Hanselman, yes or no?
Yes, that's my understanding.
Okay, the objection is overruled. Go ahead.
So when Blair came to your house, you two spoke in private.
Yeah,
It was just the two of you.
that's what private means, yes.
No one else was there.
It was private, yes.
And this was before you gave an official statement.
Yeah, Blair wanted to make sure that, see if there was anything he could do. I mean, someone had just died on the property.
So that's a yes.
Yes,
And this was before you took an official deposition.
yeah, that's what I just said.
And this was before you're testifying before us here today.
Yeah, it was back in 2018.
No further questions, Your Honor.
Thank you, Ms. Catan. Any redirect for this witness?
Yes, briefly, Your Honor. Mr. Corker, you were just asked about this conversation that you had with Blair Pickus. Can you explain for us how that affected your deposition and your testimony here today?
It didn't affect it at all. Blair came by and made sure I was okay, and that everything, to see if there was anything he could do on the property. And for me, like counsel mentioned, we were good friends. He just wanted to make sure everything was okay.
Thank you, Mr. Corker. No further questions. May this witness step down?
Yes, thank you for your time and testimony, Mr. Corker. You are excused. I guess you would resume your seat, constructive seat at council table.
Yes, Your Honor.
All right, just a moment here. All right, does the defense have any other evidence or witnesses to present at this time?
No, Your Honor, the defense rests.
All right, both sides having rested and the no provision for a rebuttal case, we now turn to closing arguments. Let me make sure I understand correctly. We will have a, oh yes, Mr. Lindsay, are you prepared to give the closing argument for the plaintiff?
Yes, I am, Your Honor.
And are we to have a time check at this point?
Yes, Your Honor. At this time, the timekeeper and myself will be direct messaging the counselors their remaining times.
Okay. Mr. Lindsay, are you prepared to begin your closing argument?
Yes, I am, Your Honor. At this time, I'd like to reserve 2 minutes for rebuttal, if I may.
Okay, 2 minutes to be reserved, and if the timekeepers could please keep that in mind as you're giving the warnings. Go ahead when you're ready, Mr. Lindsay.
The student is only as good as the teacher. And the defendant, Sidney Corker and Corker Wines, improperly trained and inadequately trained Charlie Burns how to use a heavy piece of machinery. And then they sent him to do a job on that machinery into a place that had no warning signs of the danger that lurked in the trees he was sent to trim. They failed as teachers. They failed and they failed and they failed. At the end of this trial, the judge will instruct you, ladies and gentlemen, on what negligence means. Negligence is the failure to provide reasonable care to oneself or others. And all that means is that someone had an obligation and they discarded that obligation. The defendant had an obligation to keep everyone on his property safe, to make sure they were properly trained, to make sure that Charlie was properly trained. And he discarded that obligation time after time. That is the reason why Charlie is dead. We know the defendant is negligent for 3 reasons. First, Charlie was inadequately trained. Second, he was sent with that inadequate training to do a job for the winery. And third, the place he was sent to do that job had insufficient or proper warning signs. First, we know the defendant is negligent because Charlie was improperly trained. We know that Charlie had to have been trained because he knew how to turn this machine on. He knew how to go through the specific set of 6 or 7 steps that it takes to get this machine operational. This is a complicated set of steps, but it's something that can be learned in less than a day. The defense's expert told us that in one training session, one can become legally certified to operate this machine. But that's not all we know. We heard Monty Burns testify to exactly how Charlie turned that machine on that day. Monty told us he saw Charlie fiddling about with the buttons for about a minute. To a 14-year-old without the proper or any knowledge really of a boom lift, someone turning on this machine, going through the several steps, running from one place to another, hitting an e-stop button, pulling a safety toggle, playing with a foot pedal. It looked like fiddling. But the key fact is that Charlie did this in about a minute. He went through the sophisticated steps in about a minute, something that took the defense's expert having to review notes to be able to tell you what happened. And even then had to be instructed on how to go through the exact sequence of events that make this machine operational. He knew how to turn it on because he was trained. The defendant's chief of maintenance, Mr. Pickus, was seen by the machine with Charlie moving it up and down. He got his training, but that's not what made this negligent. What made the training negligent was that it was inadequate. Dr. Faustner told us the key to training is knowing the safe operations of this vehicle. Being aware of the safety hazards and how to interact with those hazards. We know Blair couldn't have done that because Blair exhibited no signs of being aware of the safety hazards or the proper way to deal with them himself. Blair Pickus testified here today that he didn't use a spotter, that he went up alone, something that is not taught in the proper training for boom lift certification. He went within 20 feet of power lines on that machine the day before Charlie was killed, something the defendant's expert told us, again, is not part of the proper safety protocol. And not only that, there's no evidence that Blair Pickus or anyone else on the winery was legally certified to operate this boom lift. Blair was able to start the machine. Charlie was able to start the machine. Blair was able to drive the machine. Charlie was able to drive the machine. Blair was able to move the arm up and down. Charlie was able to move the arm up and down. Blair went within 20 feet of power lines. Charlie went within 20 feet of power lines. Blair didn't use a spotter. Charlie didn't use a spotter. Here, the student directly imitated the teacher, but the teacher was inadequately trained and had no ability to teach Charlie proper and adequate training of the safety hazards that are necessary to safely operate this machine. Furthermore, point 2, Charlie was sent to do a job. We know that Charlie was sent to do a job because he died on the same stretch of road that Blair Pickus, his teacher, was working on the day before Charlie died. Blair was on that stretch of road, trimming trees to let light into the vineyard on the boom lift. Now, Blair testifies that normally
5 minutes.
This machine is stored in a barn, locked. But we saw no evidence that the barn had been broken into, or that there was a lock, or that that lock had been broken into. But what Blair did clearly testify here in front of all of us is that this machine gets left out when there is a job to do for the next person, whoever that is, to use it, to operate it. And Blair used it the day before Charlie died, then went out of town. And who is on that same stretch of road operating it the next day? Charlie. But he wasn't just on that stretch of road, and he wasn't just on the same boom lift. He was there with tools. Most importantly, Monty told us he was there with a saw, the very tool that would be needed to do the job that Blair was sent to do the day before. These aren't coincidences, ladies and gentlemen. Charlie was there because he was sent to do a job that he was trained to do. It just wasn't adequate. Consider your sources here. The people telling you that Charlie had no training, that Charlie wasn't supposed to be on this machine. They're the defendant who has a lot at stake here. 3 generations of a family winery. And Blair Pickus, the best friend of the defendant, 20 years, worked for him for about 11. A man who has been convicted of fraud, convicted of lying. And ladies and gentlemen, you are allowed to weigh that evidence when determining the credibility of the evidence you've heard today. Now, finally, we know that the defendant is negligent because there were insufficient warning signs on the property in the exact place that Charlie was sent to work by the defendant's employee. We heard from Dr. Knupel. She was clear. There were not adequate warning signs in the right places. Furthermore, the power lines themselves were functionally invisible to Charlie. Now remember, Charlie is not on the middle of the road. Charlie is off to the side by the power lines, and the trees are above him, in between him and the lines. Let's get one thing, ladies and gentlemen, perfectly clear. Functional invisibility does not mean that you can't see the lines. It means that your brain is focused on other, more important things at the time in front of you. When one drives a car, they are focused on the road, the lines, the other cars, their dashboard. They're not looking at the people on the sidewalk. Charlie was focused on the trees in front of him. Charlie was focused on driving a machine that he had very inadequate experience with. He was focused on doing that job. And because of that, the power lines fell back in his mind. Something signs, proper high voltage warning signs would have cured. But the defendant, even though he knew he had to have them because he had them in other parts of the property, he didn't have them in the right spots. Ladies and gentlemen, we have a burden in this case. A burden to show to you
1 minute.
Ignorance of the evidence that the defendant was negligent. That is a burden we've met here today. The evidence is clear. Charlie knew how to go through a very sophisticated set of steps that everyone in this case has told you takes knowledge of. Knowledge he was given by the defendant's employee. Sent out on the defendant's property, in the defendant's property, the boom lift, to do a job for the defendant's winery. The only verdict that the evidence supports and that justice demands is to find the defendant, liable for the death of Charlie Burns.
Thank you, Mr. Lindsay. Closing from the defense?
Yes, Your Honor.
I actually have a question before you begin.
Yes.
My screen is actually doing something very different from what I usually see. Are you sharing a screen that has both your own view as well as the side-by-side view of the PowerPoint?
Yes, I am.
Okay, thank you.
May I proceed?
Go ahead.
Sidney Corker is not responsible for Charles Burns' death. The truth, the sad truth is that Charles Burns is responsible for his own death. He ignored and evaded every precaution that was put in his path, driving himself to his death. On the evening of October 17th, 2018, Charles forced his way into a locked barn to get to the boom lift. And while he had his brother go and climb into the boom lift, he went and looked for a screwdriver. And he jammed that screwdriver into the keyhole again and again until the engine roared to life. And after looking through the manual and the instructions, he was finally able to get the boom lift moving. Without permission and without caution, Charles took off, speeding through the Corker Wines property. And after having been drinking that day, without wearing his contacts, he raised the basket up into the air next to those power lines. And he failed to see the power lines that were right in front of him. And he ran into them, electrocuting himself, killing himself. Now, as the jury, you've been presented with 3 questions here today. It's your job to decide whether the death of Charles Burns was caused by the negligence of Corker Wines and Sidney Corker, whether the death of Charles Burns was caused by Charles Burns' own negligence, and if you think both were negligent, you have to decide whether Corker Wines' degree of fault was greater than that of Charles Burns. And in answering these questions, you have to decide what a reasonable person would do. Because a person is negligent if they do something that a reasonably careful person wouldn't do in the same circumstance, or if they fail to do something that a reasonably careful person would do. And here, Sidney Corker was a reasonable business owner, following reasonable business practices. You have to remember that we don't ask business owners to anticipate every possible thing that could happen on their property, because then no one would want to own a business. And the plaintiff, they just came before you with the benefit of hindsight, meaning that they know what did happen because it already happened. But that doesn't mean Sidney Corker could have or even should have known that it would happen. Now, the truth is that sometimes people do negligent things. And most of the time, nothing bad happens. But here, something bad did happen. Charles Burns lost his life. And that's a tragedy. But not every tragedy is the fault of someone else. And that's what the plaintiff is trying to do here today. They're trying to say that Sidney Corker is responsible just because a tragedy happened. But as the jury, it's your job to reach your verdict based on the law, not based on any sympathy that you may have. And the law makes clear in this case that no one is responsible for Charles Burns' death but himself. And we know this because he ignored the warnings on the power lines. He evaded all of the restrictions on the boom lift, and then he drove that boom lift dangerously. So I want to go through each of these with you now, starting with those power lines. Now, it's important to note here that while the power lines are on Mr. Corker's property, he doesn't own them. The utility company is responsible for maintaining those power lines. And Dr. Faustner told you today that Sidney Corker shouldn't do anything with those power lines because he's not an electrician. So Sidney Corker trusted the utility company to put up warning signs where they were needed. But even though Mr. Corker wasn't responsible for the power lines, there were still warnings on his property. The first warning being the lines themselves. They were open and obvious. You saw pictures of the scene where the accident happened throughout trial today, and you were able to see the power lines in all of those pictures. In addition to being able to see the power lines, the danger of the power lines was known. It's common sense. Power lines are dangerous. And Charles was 23 years old. He was an adult. He knew that those power lines were dangerous. And the fact that the lines were visible and that the danger was known, that alone warns Charles about the power lines. Sidney Corker didn't need to do anything else, but he did. He made sure that there were warning signs on his property, warning signs that said danger, high voltage, warning signs that Charles would have seen living on the property. Charles was warned of that danger that was above him. And I want to be very clear here that that danger was 40, 50 feet above him. He was not in danger by walking or driving on the property. The only way to be in danger is to get on something like a boom lift. And Charles ignored all of the warnings, and he put himself in danger when he stole a boom lift that he did not have permission to use. So let's talk about that boom lift. Sidney Corker put restrictions on his boom lift, starting with who could operate it. You heard today that he has over 70 employees that work for him, and only a small handful are allowed to use that boom lift. And that those employees are trained to safely operate the machine, and that they are trained on the dangers. And we know that they were trained effectively because they were driving the speed limit and they weren't hitting the power lines.
5 minutes.
Just came up here and told you that the student's only as good as his teacher. But I want to be clear, there was no teacher. No one showed Charles Burns how to operate this machine. He was not trained because he was not an employee. Blair Pickus testified before you today and told you he did not train Charles Burns. Charles Burns never told his father that he was working. There's no evidence of employment. And on the day of the accident, him and Monty were mobbing through the property, as Monty testified to. They weren't working. They were on a joyride, speeding through Corker Wines. But knowing that Sidney Corker had people on his property that weren't employees and that weren't trained, he also restricted the access to the boom lift. Now, you heard from Dr. Faustner that it's actually reasonable to leave a boom lift at a job site. It's a common practice in the industry. But Sidney Corker went a step further and locked it in a barn across the property. Blair Pickus told you that he locked the boom lift in this barn the day before the accident, a barn that only 2 people had keys to, a barn that Charles was not allowed to go into. But Charles evaded all of those restrictions by breaking into the locked barn and using a screwdriver. You heard from Monty that he saw him with tools in his hand when he was starting the boom lift. He didn't see keys because Charles didn't have keys. He used a screwdriver to start the lift. Sidney Corker could not have predicted that Charles would ignore and evade all of those precautions. But Charles did. And then he drove that boom lift dangerously. Because this case isn't about whether there were warnings or restrictions. It's about common sense. Common sense that Charles Burns did not use. Because we all know that it's reasonable to not drink and drive, that you need to look at your surroundings, that if you need corrective lenses, you should wear them, and that you should drive the recommended speed. But instead, Charles was drinking wine before operating this machine. He was messing with the controls instead of looking for warnings and power lines. He wasn't wearing his contacts that would have helped him to see those things. And he was driving over 15 times the recommended speed. That unreasonable behavior caused this accident. And we know that it was that unreasonable behavior because Montgomery Burns was right next to his brother in that lift, and he did see the power lines. And he didn't have any special training. He didn't have any additional warnings. And he was able to see the power lines because they were both physically visible and functionally visible. Because he saw them. And if Charles had been acting reasonably, he would have seen them too. And he'd still be here with us today. Sidney Corker took all of the reasonable precautions. Charles ignored and evaded all of them. And Sidney Corker could not have anticipated that. So we ask that you find Sidney Corker and Corker Wines not liable and hold Charles 100% liable. Thank you.
Thank you, Ms. Hanselman. Rebuttal closing from the plaintiff, please.
Thank you, Your Honor. Ladies and gentlemen, sometimes people do negligent things and no one gets hurt. Just like the day before Charlie died, Blair Pickus was sent out to do a job with negligently given training, inadequate, and nothing happened. But the very next day, Charlie Burns did the same thing in the same place, and that negligence did cause something bad to happen. Now, ladies and gentlemen, the defense wants you to rely on evidence such as the fact that Charlie was seen drinking wine, but there was no evidence presented to you to show you what his blood alcohol level was, or that he was intoxicated or drunk. Furthermore, they want you to rely on the idea that Charlie took the boom lift from a shed or a warehouse that was locked when there's no evidence presented to you that there was a lock or any evidence of someone breaking in.
1 minute.
Common sense. Common sense tells us that for a person to be able to go through the sophisticated set of steps that it takes to start this machine, something that a PhD had trouble explaining to us today, was done by someone who had the knowledge to do it. And Charlie Burns was given that knowledge by the defendant's employee. Furthermore, Charlie was found not just with a screwdriver, but with a saw. He was seen with a saw in the same place that Blair Pickus was in the day before. Common sense tells us that these are no coincidences. The fact that the key is now missing is no coincidence. You're up, ladies and gentlemen,
Stop.
find the defendant liable.
All right, that brings us to the conclusion of our trial. Thank you very much. I'm going to need to take a moment to allow our evaluators to complete their score sheets. Until then, I would normally try to fill the time with comments, but I'm not going to make comments before the evaluators have completed their scoring, and that includes me. So what I'm going to do is actually put myself on mute for a moment. And when I come off of mute, that means I'm ready. Then I'll check with the evaluators and then we can talk about comments. So thank you.